After writing the dictation, please press the like, share, comments and bell icon in this channel. Legal dictation at the speed of 100 to 110 words per minute. Get ready? Start. The brief facts of this case are that the respondents herein were working as reservation clerks and were posted at Indore railway station. On an information received by the Assistant Sub-Inspector of General Railway Police, Indore, that one person had illegally been purchasing tickets from reservation counters, came to the reservation office and in the process apprehended a person named Suresh Sah. From a search conducted, 94 tickets of different trains and a sum of rupees 33,403 was also found in his possession. A first information report was lodged against him. Allegedly, during investigation of the said case, he was found to have been carrying business in procuring reservation tickets illegally. The respondents were said to have abated in commission of the said offence. On the said charge, respondents with the aforementioned Suresh Sah were prosecuted. Ms. Sanjana Verma, learned counsel appearing on behalf of appellant, principally raised two contentions before us. Firstly, it was submitted that although there is no direct evidence against the respondents herein, but from the circumstantial evidence adduced by the prosecution, it must be held to have been proved that the railway tickets were being clandestinely sold in black market, and unless the respondent had abated the main accused Suresh Sah and could not have been found to be in possession of 80 tickets involving 94 reservations. It was contended that the respondents were found to have issued the tickets and keeping in view the timings of issuance thereof, as has been noticed at paragraph 21 of the judgment of the learned trial judge, it would have been impossible for the said Suresh Sah to book so many tickets within a few hours. It was also submitted that the respondents did not raise any particular defense. The High Court, the learned counsel would submit, also committed a serious error in opining that the respondents had not been asked about the circumstantial evidence or evidence appearing against them by the learned trial judge while examining them under section 313 of the Code of Criminal Procedure. Before embarking upon the rival contentions of the parties, we may briefly notice the admitted facts. At the relevant time, 11 reservation counters were functioning at the Indore railway station. Reservation offices at the said place function from 8 hours to 14 hours and then from 14 to 10 hours to 20 hours. An employee works only for 6 hours in one reservation counter. 2 of the reservation clerks were absent. The offence is said to have taken place on 2nd October 1995, just before the ensuing Durga Puja festival. There were long queues. Ordinarily, minimum 2-3 minutes time was required for issuance of one ticket. Indisputably, a circular was issued in terms whereof one reservation form could be given to one person. He, however, would be entitled to ask for reservation of 6 seats for passengers. If one person intends to obtain more than one reservation form, he is required to take permission from Divisional Commercial Manager. However, indisputably, a person intending to obtain reservation for more than 6 persons can make his associates stand in the queue or come again and again demanding reservation forms. During Diwali, Dasahara, and summer holidays, in view of rush, admittedly, at least 20 persons remain in queue in such reservation window. Documents maintained in the reservation office had not been seized. No excess amount was found at the cash counter. No extra cash was also found on the person of respondents. In the reservation forms, handwriting of the accused Suresh Shah was allegedly found. It stands admitted that the reservation forms were handled in different counters. Out of the 6 accused persons, 3 were in the morning shift and 3 were in the evening shift. Thank you so much.